Professor Andreas Zimmermann. You have the floor, Professor.
Merci, Monsieur le Président. Mr. President, members of the Court. Let me start by expressing my honor to appear once again before the Court. This is even more true this time, since the current proceedings address issues that have been of utmost relevance for the international community for decades, and indeed for the United Nations since its very inception. These issues lie at the very heart of the organization's ability to achieve international peace and security, now more than ever. I will present Palestine's arguments on jurisdiction and admissibility. I can and will be succinct, as there is no doubt that the Court has jurisdiction to give the requested opinion and that there are no compelling reasons for the Court to decline to issue the requested opinion. Rather, to the contrary, compelling positive reasons exist for the Court to address the legal questions referred to it, as the Court's legal determinations will assist all parties as to the legal parameters that must be adhered to. The Court's determinations are both urgent and relevant, given Israel's manifold violations of preemptory norms of international law, which continue and intensify on a daily basis. Mr. President, the Court clearly has jurisdiction to provide the requested opinion. The General Assembly is obviously competent to request the opinion in line with Article 96(1) of the Charter. Moreover, Resolution 77-247 was adopted by a clear majority and in full compliance with both the requirements of the Charter and the Assembly's Rules of Procedure. The questions posed by the General Assembly are also plainly legal in character. And as the Court has repeatedly and consistently confirmed in its jurisprudence, the fact that the questions may have political implications is irrelevant and does not bar the Court from fulfilling its essential judicial function. Further, there is no reason, let alone a compelling one, for the Court to decline to issue the requested opinion. On the contrary, manifold reasons exist which confirm that an answer by the Court to these questions is of utmost importance for the General Assembly, the United Nations at large, and the international community as a whole. First, the questions concern serious breaches of jus cogens and erga omnes norms. As my colleagues will show, those breaches by Israel include violations of the prohibition of acquisition of territory by force, the prohibition of racial discrimination and apartheid, the denial of the right of self-determination, as well as other egregious violations of international human rights and humanitarian law of the same character. Accordingly, all states, as well as the United Nations in toto, have a legally protected interest in having those violations in both their individual and cumulative manifestations, as well as their legal consequences laid out and clarified by the Court, so as to guide them in their future actions. Second, the questions concern the United Nations' continuous responsibility for resolving the question of Palestine. This responsibility stems from its duties relating to matters of international peace and security arising under the Charter and, as the Court put it, quote, has its origin in the mandate and the partition resolution concerning Palestine, end quote. This responsibility continues as confirmed by the unequivocal and contemporary practice of the General Assembly, the Security Council, as well as other United Nations organs and bodies. And as the Court had previously reiterated in its Wall Advisory opinion, there exists, and I quote, a permanent responsibility of the United Nations towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy, end quote. The questions put before the Court by the Assembly thus seek the Court's legal guidance on matters of fundamental and long-standing importance and concern to the United Nations. Third, all of the grounds for declining to issue an opinion suggested in the submissions of a few states fall far short of constituting compelling reasons that must exist for the Court to refrain from answering the General Assembly's questions. Some of these submissions oppose the advisory opinion because of the purported existence of a negotiation framework or of bilateral negotiations. However, none of these considerations constitutes a reasonable basis for the Court to refuse the General Assembly's request. To the contrary, an opinion from the Court will assist in these negotiations by confirming the applicable international legal framework as affirmed in United Nations resolutions in order to reach a just and peaceful solution. As a matter of fact, there exist at least three reasons why the Court should not be deterred from answering the GA's questions on that basis. First, Israel has repeatedly refused, and to this very day, to engage in meaningful negotiations with Palestine on the basis of international law and United Nations resolutions. This is reflected in repeated statements, including, most recently, by the Israeli Prime Minister and other high-ranking Israeli officials. The mere hypothetical possibility of future negotiations cannot thus be used as a mere pretext for avoiding the application of international law to this crucial matter, or for avoiding responsibility for ongoing breaches of preemptory norms of international law. Israel has made it clear that it wants and will tolerate only one state, Israel, between the Mediterranean Sea and the Jordan River. This is confirmed inter alia by the map displayed by the Israeli Prime Minister in his speech before the General Assembly of 22 September 2023 that you have already seen, as well as by his November 2023 statement where the Israeli Prime Minister said that he was proud to have prevented the establishment of a Palestinian state. But these statements of Israel's head of government have not been empty words. Rather, they are reflected in concrete policy decisions and measures on the ground undertaken by Israel for decades. Inter alia, when faced with the attempt by Palestine to initiate the conciliation procedure under Articles 11 and 12 third, it was Israel that consistently and continuously rejected any meaningful attempt to bring to an end, by way of negotiations under the auspices of the ad hoc commission set up under Article 12 third, its entrenched system of racial discrimination inherent in its occupation regime. Second, and significantly, the Security Council has repeatedly called for a peaceful settlement of the question of Palestine based on international law. It renewed this call only 2 months ago in December 2023 in its resolution 2720, when reiterating that a solution to the conflict must be, and I quote the Council, consistent with international law and relevant UN resolutions, end quote. The Court's opinion can thus only contribute to achieving the peaceful settlement of the question of Palestine called for by the Security Council. Your opinion, will clarify the legal rights and obligations of Israel, of Palestine, of third states and of the United Nations to be reflected in a settlement that is truly consistent with international law. Thus, the Court's opinion will also contribute to upholding the international rule of law at large. In that regard, let me remind you, members of the Court, that this is precisely what the Court's advisory opinion in the Chagos proceedings achieved. By clarifying the relevant legal rules, your opinion, broke the deadlock that had precluded negotiations. The advisory opinion, your opinion, led the United Kingdom to agree to negotiate with Mauritius for the first time on the basis of Mauritius' sovereignty over the disputed territory. Third, the General Assembly, when deciding upon the request for the current advisory opinion, was acutely aware of the claim that such request would somehow purportedly undermine the chances of future negotiations. Nevertheless, the General Assembly decided to ask for the court's legal determination anyway. The General Assembly thus found that this argument had no merit. To the contrary, the GA considered that the court's opinion would be helpful as to future steps to be taken by the political organs of the United Nations, as well as by all states. In line with your role as one of the principal organs of the organization, as envisaged in Article 7 of the Charter, the Court ought not now set aside this considered decision of the General Assembly. Members of the Court, the mere hypothetical chance of possible future negotiations cannot and ought not prevent the Court from rendering its opinion. If this were the case, quod non, a reluctant state wishing to bar the Court from exercising its judicial function could unilaterally prevent the matter from reaching the Court by simply insisting on the mere possibility of negotiations. This would curtail the General Assembly's right to receive legal assistance from the Court, and to do so even in a situation where the General Assembly, making the request, determined that such opinion by the Court would be needed for the exercise of its own function. Such approach finds no basis in the wording of the Charter or the Court statute either. It would unduly limit the right of the political organs of the United Nations to request an opinion from the Court on any, as the wording has it, on any legal question, as both 96(1) Charter and 65 of the Court statute provide unequivocally. Mr. President, members of the Court, let me conclude. The catastrophic developments of recent months in the Gaza Strip confirm that the matters put to the Court by the General Assembly are, if ever there was need, not mere bilateral issues. Rather, they are issues of grave consequence for the maintenance of international peace and security. They are thus of immense concern for the international community at large, where the Court's legal guidance is desperately needed. All of these aforementioned considerations corroborate that in the present proceedings, as indeed in each and every previous advisory proceedings that had come before this Court, there are no reasons, no compelling reasons to prevent the Court from rendering its opinion. Rather, Palestine invites the Court to fulfill its duty of providing its legal determination to the General Assembly by answering the legal questions put to it. In so doing, you will assist all states, as well as the United Nations, in furthering respect for the international rule of law, the fulfillment of the inalienable rights of the Palestinian people, and a just and peaceful solution in accordance with international law. Members of the Court, I thank you for your kind attention and would now kindly ask you, Mr. President, to call upon Mr. Reichler to take the floor. Thank you.